officers presented before this court for reports. 2 are victim impact statements, 1 for the hotel complex and another for the late Jason Jacob, a victim of the attack, and the other 2 are pre-sentence reports for the 2 convicts. I shall rely on the substance of this report in my ruling as and when they apply in the analysis. In addition to these reports, counsel for the prosecution and for the convicts have both made submissions. I have considered the submissions by both the prosecution and defense counsel, therefore, in my analysis. As highlighted in the submissions, the prosecution has argued for a maximum sentence for both offenses and that both should run consecutively. On the other hand, counsel for both accused persons have urged the court to impose a lenient sentence in both counts and that the sentences should run concurrently. It is strike law that when a court is faced with more than one offense, the overriding principle of totality of sentencing is that the overall sentence should be just and proportionate. Further, the sentence should reflect the behaviors with reference to the overall harm and culpability together with the aggravating and mitigating factors. Even so, sentencing is a complex arena and this court must seek guidance from the Sentencing Policy Guidelines 2023 in respect to the principle of concurrent and consecutive sentences. See paragraphs 2. Paragraph 2, that is of the guidelines, provides as follows: notwithstanding the provisions under the CPC and the Penal Code summarized in paragraph 2.3 above, the discretion to impose concurrent or consecutive sentences lies with the court. There are 2 elements to the concept of totality, and these apply as much to terms of imprisonment as they do to community service and fines. Firstly, all courts, when sentencing for more than one offense, should pass a total sentence which reflects all the offending behavior in a way that is just and proportionate. This is whether the sentences are consecutive or concurrent, and will usually mean that concurrent sentences will result in a longer sentence overall than a single sentence for one offense. However, the court must avoid double counting where the additional offenses are auxiliary to the main offense, e.g. robbery with violence, robbery with a weapon. The presence of a weapon, an intrinsic part of the main offense of robbery, will likely aggravate the sentence on robbery, and so the weapon should run concurrently and will not necessarily exceed the sentence for the robbery itself. Secondly, it is rarely possible to arrive at a just and appropriate sentence by simply adding together single sentences for each offense. The court must address the offending behavior as a whole together with the personal circumstances of the offender. Accordingly, the court must bear in mind the purposes of sentencing set out in paragraph 1.3. A concurrent sentence will normally be appropriate where the offenses arise out of the same incident or facts. For instance, poaching of several animals that vary in the degree of protection they are afforded under the law, a burglary spree of several properties committed in one night, fraud and associated forgeries, or a dangerous driving incident where multiple victims are injured as a result of one offense of dangerous driving, etc., etc. A consecutive sentence will normally be appropriate where the offenses arise out of unrelated facts or incidents, e.g., attempting to obstruct the course of justice in relation to unrelated offense, where the defendant is convicted of dealing in drugs and also possession of a firearm upon arrest. The firearm is not an intrinsic part of the drugs matter and requires separate recognition, or where the accused commits a theft on one occasion and an assault on a different victim on another occasion. A consecutive sentence may also be appropriate where the offenses are of the same or similar kind, but where the court is of the view that a concurrent sentence will not sufficiently reflect the overall criminality. For instance, assault of a police officer whilst trying to evade arrest of the original offense, assault of the same victim committed in the context of domestic violence, or where there are sexual offenses against the victim. What then is the appropriate sentence in this case? From the above provisions, it is clear that the discretion to impose either a concurrent or consecutive sentence lies squarely within the jurisdiction of the court. The objective is to ensure that the sentence imposed is not only legally sound, but also just and appropriate in light of all the circumstances. As such, to make this determination, it is incumbent upon this court to weigh the aggravating factors against the mitigating circumstances presented by both defense and prosecution counsel. This exercise is not merely arithmetic. It is a careful balancing act that requires assessing the totality of the offending conduct, the level of culpability, the harm caused, and the role each convict played in the commission of the offenses. Stand up. Stand up, both of you. Okay. Number one, the aggravating circumstances. Use of a weapon to frighten or injure a victim. The convicts may not have physically wielded the weapons that caused harm to the victims, but their facilitation directly enabled attackers who were heavily armed with guns, grenades, and suicide vests. The very The victim impact reports note that one of the survivors of the attack still has a bullet or bullets lodged in his body that has resulted to medical complications and substantial medical bills that continue to strain his financial resources. In addition to the primary victims, the pre-sentence reports note that several secondary victims who lost loved ones continue to grapple with grief. Many vividly recall memories of their departed family members and friends and struggle to find closure. The emotional scars left by the attack runs deep, affecting their daily lives and mental well-being. One such secondary victim is the family of the late Jason Jacob Spindler, an American citizen who was hailed by his family as being a brilliant, kind, and determined man who brought joy to not only his family but to all the people with whom he interacted. The family remains heartbroken and grieving for not only the loss of their son, but also the irreparable fracture of their family stemming from his death. Despite the family seeking grief counseling to help address the immediate needs arising from the psychological and emotional harm from the loss of their son, the father stated that his mother is still undergoing therapy currently, more than 6 years after the death of their son. They attribute the death of their son to an ideology that continues to threaten the lives of countless others, perpetrated by monsters who choose terror over humanity. An ideology that they stated viewed the death of an innocent people as a victory. It is on these grounds that they hope that this court will pass a sentence that matches the weight of their loss. Other secondary victims expressed their hesitation to be interviewed by the probation officers, citing the pain that they still experience after the loss of their loved ones. The collective voices of the victims, as captured in the pre-sentence reports and victim impact statements, reflect the gravity of the impact of the attack. The reports further note that the community as a whole has been impacted with lingering fears and anxieties about safety, which have altered social dynamics and contributed to a pervasive sense of vulnerability. Excuse me. C. Grave impact on national security. The attack shook the core of Kenya's security apparatus. It was not just an assault on a building, but on public confidence, national morale, and international perception. The attack exposed our country as a danger zone to the extent that tourism was affected to a great extent. The pre-sentence reports, in fact, note that the tourism sector which is a critical component of Kenya's economy, was especially vulnerable to the negative perceptions of safety that arose from the Dusit D2 attack. The resulting decline in tourist confidence led to decreased revenue for businesses reliant on tourism, including hotels, restaurants, and local attractions. D. Serious physical or psychological effect on victims. Some of the victims who testified during trial are still haunted by what happened. They spoke about the flashbacks and anxiety following the attack. Others lost colleagues, jobs, and a sense of safety that may never return. The pain did not end with the attack. When the attack did, it just began. It is noteworthy from the pre-sentence reports that survivors of the attack listed for the victim impact statements declined to participate in the interview for several reasons. The incident remains fresh in their minds, and many expressed that engaging in discussions would only rekindle painful memories of the tragedy. According to the reports, one survivor specifically cited the heartbreaking experience of losing his source of livelihood as a self-employed individual. The totality of the foregoing is that the victims and survivors of the attacks are still suffering from the gravity of the attack and do not wish to relieve it. E. Intricate planning of an offense. This was no spur-of-the-moment crime. I already found in my judgment that the first convict played a central role in forging identification documents that facilitated the movement of the attackers without detection. Similarly, the second convict clandestinely wired money in strategic intervals, which finances facilitated the attackers' food, shelter, and freedom to plot the attack. That kind of coordination shows deep involvement of the convicts in the planning of the attack. F. Attempt to conceal or dispose of evidence. As I already found in my judgment, the second convict forged the death certificate for his own brother just to cover up his footprints. This was a calculated move to throw the investigators off and bury his digital footprints. Such level of deception, in my view, is a serious aggravating factor. G. Flagrant use of violence or damage to person or property. The attackers, who were facilitated by the convicts, did not just harm people. They ravaged an entire building. The Dusit D2 hotel complex was riddled with bullet holes, blood stains, and bomb damage. The violence was not just intentional, but excessive, and left both human and material destruction in its wake. The victim impact statement for the hotel has captured the grave losses incurred both on the property and its economic benefits generally. The report notes that since the attack, the occupancy rates has plummeted from 100% to a paltry 55%, leading to many business closure. It also resulted in a drastic reduction of human traffic from 2,500 people to around 200 people daily. This decline has severely impacted on the economic thrive of the complex, and the losses have also caused the employees to lose some of the benefits that they initially had, such as insurance covers. Commission of the offense in a gang group. As already analyzed and found in my judgment, this was a conspiracy involving multiple actors working in concert. Each one had a role to play, either in planning, funding, forging, or attacking. The coordinated nature of the offense makes it more dangerous and more difficult to prevent or disrupt. Mitigating factors. In considering the appropriate sentence, I'm also mindful of the mitigating factors that have been placed before this court. First, both convicts are first offenders with no prior criminal records. This weighs in their favor as the law recognizes that first offenders should be granted an opportunity for rehabilitation where appropriate. Secondly, neither of the convicts was directly involved in the physical execution of the Dusit D2 attack. While they played enabling roles, the actual violence was carried out by others. Their culpability therefore lies in facilitation and not direct commission. I also take into account the ages of the convicts. The first convict is a young person. he has the potential to reform and reintegrate into society. And this cannot ignore the possibility, and this court cannot ignore the possibility of rehabilitation. On the other hand, the second convict is elderly, aged 61 years, and presents as physically vulnerable. Any custodial sentence imposed on him will naturally weigh more heavily due to age-related frailty. Additionally, according to the pre-sentence reports tendered for each convict, both have expressed remorse. While they maintain they did not intentionally contribute to the commission of the terrorist act, they nonetheless acknowledge the consequences of their actions. They urged the court to exercise leniency, having reflected on the pain and loss caused by their conduct. Lastly, I note from the pre-sentence reports that both convicts are of good character and social standing. The family of the first convict, both during the trial and in the pre-sentence report, described him as a bright student with promise. Similarly, the second convict is regarded as a respected elder in the community and a pillar within his family and community. My remarks. I have juxtaposed the seriousness of the aggravating circumstances vis-a-vis the mitigating factors, and I'm inclined to agree with the prosecution that the appropriate sentence should be a consecutive sentence. While the offenses are linked by a common objective, they involved distinct acts of criminality, facilitation of terrorism, forging documents, and conspiring to commit a terrorist act. Each of these acts has a separate legal and moral weight, and each caused or contributed to distinct forms of harm. A concurrent sentence would fail to adequately reflect the full scope of their criminality. Furthermore, the principle of totality does not mean that separate offenses should merge into one indistinct punishment. Rather, it calls for a sentence that fully captures the gravity of the conduct as a whole. In this case, I am persuaded that not only a consecutive sentence can appropriately address the level of culpability of the convicts and the devastating consequences that followed. I'll take that again. In this case, I am persuaded that only a consecutive sentence can appropriately address the level of culpability of the convicts and the devastating consequences that followed. In the case of Peter Mbugwa Kabui versus Republic 2016 EKLR, the Court of Appeal stated as follows. I quote, "The practice is where a person commits more than one offense at the same time and in the same transaction, save in very exceptional circumstances, to impose concurrent sentences. That is still good practice. As a general principle, the practice is that if an accused person commits a series of offenses at the same time in a single act transaction, a concurrent sentence should be given. However, if separate and distinct offenses are committed in different criminal transactions, even though the counts may be in one charge sheet and one trial, it is not illegal to mete out a consecutive term of imprisonment. The Court of Appeal was satisfied in the case above that since the offenses were committed at different times, dates, and against different complainants, the trial court and the High Court did not err in ordering consecutive terms for the different counts. The case before me exemplifies the exceptional circumstances foreseen by the Court of Appeal in the above case. Even though the end goal of the offenses was one, that is to attack the hotel complex, this is an exceptional case where multiple lives were lost, several individuals suffered serious injuries, and there was massive economic losses. Each life lost caused grieving in a family. Had the convicts not facilitated the terrorists, the attack would not have occurred. Had the first convict not facilitated the procurement of false student identity cards, the two terrorists would not have easily traveled from Dagdale refugee camp to Nairobi without detection. Similarly, terrorists need money and people to commit offenses. They need finances for their activities, for planning and survival. Had the second convict not facilitated the funds, the attackers would not have been able to sustain themselves in Nairobi, a very expensive city. In my judgment, I indicated that the attackers used the finances to live a comfortable life, to purchase household items, to the extent of purchasing a motor vehicle. Each transaction made by the second convict enabled the terrorist attack. It is therefore evident that without financiers, facilitators, and sympathizers, terrorists cannot actualize their activities. Terrorist sympathizers turn a blind eye to the activities of terrorists and deliberately aid them under the pretext of brotherhood. While they see some things happening, they fail to say something to law enforcement officers. The Dusit D2 terrorist attack was committed by individuals who had made up their minds to die for the cause. The lead attacker, Ali Salim Gishunge, for instance, left a letter to his wife asking for forgiveness for what he was about to do and hoped to meet her in the afterlife. Indeed, they all died for the cause. The question that begs is, who is to be held accountable for the heinous and egregious crimes that were committed by the attackers? The answer is obvious. It is those who facilitated the activities that subsequently culminated into the attack. These individuals must now be answerable to the victims and the nation. The totality of the factors enumerated above, in my view, are the exceptional circumstances that aggravate the nature of the offenses. The Supreme Court in Republic versus Ahmed Abulfadi, that is the Iranian case, recognized the notoriety of terrorism attacks in our country and called for the courts to take the front line in the fight against terrorism within the rule of law. The court had this to say, and I quote, "This calls for vigilance of all Kenyans, including judges and judicial officers. For judges and judicial officers, their vigilance has to be within the confines of the rule of law. They cannot, for instance, act on public outrage of the offenses of terrorism and ignore the law. While they must jealously guard an accused person's right to a fair trial, the courts should equally guard public interest by ensuring that those who commit or plan to commit terrorist offenses do not escape punishment." End of quote. In line with the foregoing, the contribution of this court towards the fight against terrorism is in meting an appropriate sentence for the offenses that were committed. The goal is not to punish disproportionately, but to ensure that justice is done fully and transparently. In my view, therefore,